Hi, my name is Luke Jared Anthony, student ID 0344099, and today my video presentation will be the discussion if Marcus and Penelope are required by law to leave the basement flat which they have entered into an agreement with Aaron pursuant to the license agreement mentioned in the question. In order to determine this, one has to know if it's just a lease or merely a license. Section 1 Sub 1 Sub B, the Law of Property Act 1925 states that only estates capable of being conveyed or created by law are freehold and leasehold. For a leasehold, according to Section 205 of the Law of Property Act 1925, a leasehold is for a duration of years, whether or not at rent, and can be terminated by notice. In the landmark case of Street versus Montfort 1985, the test was whether, based on the facts of the case, the occupancy of a residential accommodation was a tenancy or a license. Lord Templeman held that the traditional distinction between a tenancy and a license is whether they have exclusive possession for a term at a rent. If they do, it is binding on third-party purchasers. Tenants are also protected under the Rents Act 1977. Tenants also have exclusive possession of the said property. On the other hand, if it is just a mere license, it is just an arrangement personal in nature between the grantor, licensor, and the grantee, licensee, whereby the latter may occupy the licensor's property for a specific purpose and that right cannot be assigned to another. If it is just a license, the arrangement cannot be binding on third parties. The licensees are also not protected by the Rents Act 1977, and the licensee has only exclusive occupation of the place and not exclusive possession. But what is exclusive possession? Exclusive possession is the legal right to occupy land to the exclusion of all others, including the landlord himself. Here, the issue is to determine whether Marcus and Penelope have exclusive possession of the flat in light of the fact that Aaron was allowed to enter the flat every Friday afternoon to remove the recycling and to also utilize the flat every Saturday afternoon for choir practice. In the case of Crankor versus Da Silva Sir, 1986, the courts held that exclusive possession was not present as the agreement required the landlord to provide attendance and services which would have required unrestricted access to the property. However, in the case of Aslan versus Murphy 1990, the fact that the tenants were asked to vacate the premises at certain periods during the day, this did not negate exclusive possession. The courts held that it actually proved exclusive possession because the contractual term was needed to ensure that the tenants would leave the property at the pre-designated periods, and it was not that the landlord could just come and tell them to leave whenever he wanted to. Based on this decision, it can be said that Marcus and Penelope have exclusive possession, as terms on the agreement have clearly stipulated the specific time and day. This would not invalidate exclusive possession. According to Lord Denning in Marchant and Charters case 1977, the question whether he was a licensee or a tenant would depend on the nature and quality of the occupancy and not the words used in the agreements. In Ashburn-Ansalt versus Arnold 1989, the courts decided that rent is not essential requirement for a valid lease. This is in line with Section 205, Sub 1 of the Law of Property Act 1925, where the definition clearly spells out for the term of years whether or not at rent. On the facts, it is clear that Marcus and Penelope have to pay $1,000 each month and can be construed as rent, regardless of the terminology used. For example, here, license fee. Rent must also be for a specific duration and can be terminated with due notice. However, it cannot be for an indefinite period. In Lace and Chandler 1944, the tenant was granted a tenancy of a house for the duration of the war. and the lease was held to be not fixed as the duration of the war was not certain. This principle was followed in the case of Prudential Assurance versus London Residential Body 1992, where the original lease was held to be invalid because the term was uncertain. Going on the basis that Marcus and Penelope have exclusive possession of the flat, then the next element is to determine if the duration of the rent, here the license granted to Marcus and Penelope as until such time as England wins the World Cup. This clearly is an uncertain duration, as such specific performance could not be awarded to enforce the contract for a lease as an equitable lease. In the case of Beresford versus Maxfield 2001, the Supreme Court held that if there is an uncertain term was granted to an individual, the old common law rule treats the lease as a lease for life, terminating if uncertain events occurred, though on the demise of Craig versus Brown. Under Section 149, Sub 6 of the Law Property Act 1925, lease for life is converted to a lease for 90 years, terminable by death. The facts are silent whether the agreement was entered by Marcus and Penelope was registered and had complied with the legal requirements to give it effect as a legal lease. However, based on the above discussion, Marcus and Penelope's agreement can be recognized as an equitable lease. In Walsh versus Lansdale 1882, equity looks on that as done which ought to be done. Under equity, the lease is enforceable under specific performance. In order for a specific performance of equitable lease, the agreement must be subject to payment of rent or consideration. Here we know that Marcus and Penelope are required to pay £1,000 each month. The agreement must be in writing in order to satisfy Section 2, Sub 1, the 1989 Act. Here it is stated that Marcus and Penelope were asked to sign a document, thereby indicating a written document. Moving on, the claimant must not have breached the agreement. Specific performance may not be granted if the tenant breaches its obligation, which can be seen in the case of Cotsworth versus Johnson, 1886. Here, there is nothing on the facts to indicate that Marcus and Penelope have breached the agreement in any way. Notice to terminate is for minimum for 4 weeks. This is under the Protection from Eviction Act 1977. Otherwise, the notice of the full period in order to terminate the contractual tenancy. The notice must be clear and not misleading, otherwise it would be invalid, as held in the case of Manna Investment versus Eagle Star Assurance 1970. In advising Marcus and Penelope based on the above discussion, despite them signing a document calling a license agreement, it can be said from the facts and that the nature of the agreement between them and Aaron is a tenancy as opposed to a mere license. Further, it is stated that Zane had informed Marcus and Penelope to leave the flat by the end of the month. Following the requirement under Protection Act Eviction 1977, the minimum requirement of notice to terminate a tenancy should be served 4 weeks. Since it has been established that Marcus and Penelope have an equitable lease, their arrangement with Aaron is binding on Zane. Furthermore, Marcus and Penelope can claim protection under the Rents Act 1977 and seek for specific performance of their lease against Zane. Thank you.